Thank you, my lord. It's been impressed on me to say that I think I may have until 3:25 today, because I think Mr. Gillis was 10 minutes overrunning on his quarter past this morning.
Yes, very well.
Thank you. Sorry to be finicky about the minutes. My lord, I was just showing you, before we broke, or trying to show you just a copy of the custody confirmation itself. Hopefully you received an electronic document entitled Custody Confirmations. If you go to page 3 of that, you have the 5th of April 2005 custody confirmation, which is the text of the letter we've been looking at. And if you go over then to page 4, you see the important schedules to it, which set out the purported T-bills held by Bill Miss and with the HSBC stamp on it. They were initialed by the officer of HSBC. So that is the custody confirmation, which figures large in the debate in this case. Now, as I say, my learned friend was wrong to say that had been disclosed in March 2015. It was disclosed for the first time on the 7th of October 2016. My learned friend referred to a chronology at 2092. If we can just go to that quickly, which is the chronology HSBC have prepared and impressed on your lordships that you should read this. If I could just make one point, just to show the care that needs to be taken.
I beg your pardon, could you just give me the page for that again?
It's 2092, and I'm going to page 2093 of the chronology.
Thank you.
There's an entry on 2093, item 5, you'll see, where it said that what was disclosed on the 13th of March 2015 included the custody confirmation which Primeo relied upon for 2005, which alleged provided a custody confirmation of the Bill Miss assets. That, again, is wrong. If you look at the footnote 9, it refers to a document N1633.2. If you go back to the clip, the first document in the clip I showed you is N1633.2. And it is a letter, but it has absolutely nothing to do with the Bill Miss securities. It's not the April 2005 letter, which is the critical one. It refers to certain cash balances. It has absolutely nothing to do with the issue we're concerned with. So that entry is wrong. So far as we're concerned, the first time we received this was on the 7th of October 2016. Now, it's therefore, we say, entirely unsurprising that the custody confirmations were not pleaded. They were not pleaded. That was an entirely function of the timing of the disclosure, and it was entirely of the respondent's own making. Now, the second point, in those circumstances, Primeo was permitted by the judge at trial to rely on the custody confirmations. We say that's entirely unsurprising given the chronology. The respondents did not, in fact, object when the relevant documents were opened by Primeo, put to the witnesses. We deal with that in paragraph 51 of our reply written case at E2331. Objection was not taken by the respondents at the time. Understandably so, we say, because one can imagine the reaction it may have got, given the disclosure issue, and it's far too late for them to raise it now. Thirdly, even if the respondents had objected at trial, in our submission, permission to amend would undoubtedly have been given. In this respect, the causation argument based on the custody confirmation was no more than a development of Primeo's existing case. And certainly given the timing of the disclosure, it can hardly be said to have been Primeo's fault that it wasn't pleaded earlier. Now, against that background, it's unsurprising, we say, that the judge permitted Primeo to rely on the custody confirmations at trial. He was plainly correct to do so. Indeed, we put the point the other way round. It's Primeo which was prejudiced by the very late disclosure of the custody confirmations, which meant that it had much less time to prepare its case than it should have had. These should have been disclosed back in 2014, 2015. We could have prepared the case. We would have been able to marshal the pleadings, the evidence, and so on and so forth. It's Primeo that has been prejudiced by what happened in relation to this.
But are you, when you talk about prejudice, are you talking about your damages claim or your claim in respect of liability arising out of the custody confirmations? Because as to the latter, you were allowed to
We were.
introduce it and you won on it.
We did, yes. We did.
So are you saying that you were disabled from pleading a proper case as to causation of loss on a loss of a chance basis?
Well, yes. I mean, we were certainly disabled from pleading a case. We didn't have the opportunity to plead any case. And the custody confirmations, your Lordship's right, are relevant both to liability and to causation and loss and damage.
Right, but I don't want to go back over the ground we went through this morning, but I mean, might it not be said that, yes, it's unfortunate and it may be a ground of criticism at some level of the respondents that you get the custody confirmations so late, but you make them part of your case for liability?
Yes.
As I understand, you make them part of your case also in respect of causation.
Yes.
But it said that you didn't plead out your case in relation to causation on a loss of a chance basis. You pinned your colours to the balance of probabilities case that you did present.
Well, there was no, I mean, for first point, I mean, there was no pleading of the custody confirmations at all. There was no pleaded case. So, I mean, the most that, and as I explained the reason why that was, I mean, the most you can say is that as part of the argument in closing, the loss of the chance point ought to have been articulated specifically in relation to the provision of the audit opinion, and we accept that it wasn't. I mean, we haven't disputed that point that's recorded in the Court of Appeal's judgment. Now, that I think I was just dealing then with the first of my loan defence point, which is, well, we shouldn't have been allowed to run the custody confirmations at trial. The second point is, well, was the Court of Appeal right to allow us to entertain, was the Court of Appeal right to entertain the loss of a chance argument on appeal in relation to the provision of a clean audit opinion? And we say they were, and clearly so. I think there's probably 5 points we make in relation to this. The Court of Appeal's own reasoning is at paragraph 333 of their judgment. The first point is that in our submission it's important to understand how the loss of a chance doctrine applies, both in relation to causation and then quantum. And this is dealt with by the Court of Appeal in Allied Maples, page 1614, E2556.
Page again, please.
2556. It's a passage alongside letter D, Lord Justice Stuart Smith. And he refers to the distinction between causation and quantification of loss. But in my judgment, the plaintiff must prove as a matter of causation that he has a real or substantial chance as opposed to a speculative one. If he succeeds in doing so, the evaluation of the chance is part of the assessment of the quantum of damage. The range lying somewhere between that just qualifies as real or substantial on the one hand and near certainty on the other. So loss of a chance is part of the test for establishing causation, as a matter of fact. Once you establish causation, then the precise figure one attributes to the loss of a chance is then evaluated as part of assessment of damages. That's the first point, how the loss of a chance principle actually works. The second point is that the test for causation is a matter of law. The question of what test for causation is to be applied is a straightforward question. You simply have to identify whether the chain of counterfactual involves the hypothetical act of a third party. That doesn't involve any difficulty at all. It's not said that the Court of Appeal erred in identifying this part of the chain of causation, namely the provision, hypothetical provision of the audit opinion, as being involving the hypothetical act of a third party to which the loss of a chance principle applies. Third, the application of the loss of a chance test to the causation question also causes no difficulty, and didn't cause any difficulty, in fact. Once you apply the loss of a chance test, the question was simply whether there was a real and substantial chance that EY would not have produced a clean audit opinion. That is the actual question raised by the application of the principle. so far as causation is concerned. That question was dealt with by the Court of Appeal without any difficulty, and indeed it's not said they were wrong. If you go to 331 of the Court of Appeal's judgment at 306, it's the third sentence of 331, and this is actually their conclusion on loss of a chance insofar as it applies to causation. In our judgment, there is undoubtedly a real or substantial rather than speculative chance that EY would not have produced a clean audit opinion in the counterfactual world. Now, the making of that finding involved no difficulty at all. It didn't involve any further evidence. And moreover, it's not said to be wrong. Mullenfred doesn't appeal that finding. He doesn't say they erred in coming to that conclusion. So one is at a situation where the Court of Appeal, rightly in my submission, have established that there is in fact causation. And they've been able to do that without needing any further evidence. And self-evidently, it's not a difficult point. It didn't require, in my submission, much difficulty for them to be able to reach that conclusion. Now, the fourth point is that the assessment of the chance, once you've got over the stage of establishing causation, the assessment of the chance is part of the assessment of damages. Now, as to that, although no order for a split trial was made, by the end of the trial, it was already accepted there would need to be some form of further hearing dealing with quantum. And we deal with that in our written case at paragraphs 178 to 179. That means, in our submission, the present case is in fact close. It's not identical to, but it's close to the situation in Allied Maples, where there was a split trial. But moreover, as I explained earlier, the judge in his judgment didn't deal with any quantum issues at all. It's nowhere dealt with in his judgment. He didn't deal with any issues at all as to the quantification of loss and damage. Now, entirely unsurprisingly, the Court of Appeal's judgment, therefore, was that if liability was established, there would have to be a further hearing before a judge sitting in the Grand Court. In fact, that's the only conclusion they could have reached, because there wasn't any material on quantum set out in the judgment. So the moment they concluded that there was liability, it was always going to have to go back to the Grand Court for assessment of damages. And you see that, I mean, we've looked at the passages already, I won't waste time to go to them, but you see it at 227 of their judgment, E265, and also 335, where, this is E308, where they refer to the judge dealing with the quantification of damage and make it clear that it would be for him to deal with the quantification of the loss of a chance. Now, in those circumstances, in our submission, there's no unfairness whatsoever in saying that the loss of a chance issue should be resolved as part of the assessment of damage. Clearly the right thing to do in the circumstances. They've established without difficulty that there is factual causation. It's going to have to go back on any view to the Grand Court to deal with quantum. And there's no difficulty in our submission in loss of a chance being dealt with as part of the exercise of establishing quantum, which is how it falls to be dealt with on the authorities. Now, likewise, the reason why the Court of Appeal did not themselves fix the percentage chance is that this is properly part of the exercise of assessing and quantifying damages. That's clearly how they perceived it, and that's clearly what they understood would happen. Now, in addition to those points, in my submission, the Court of Appeal would also have been entitled to take into account the unsatisfactory way in which the custody confirmations issue arose. I accept my Lord Sale's point that the custody confirmation was provided 4 weeks before the trial. But the fact of the matter is Primeo was deprived of the opportunity to prepare its case in the normal way. It didn't have the opportunity to plead a case based on the custody confirmations. And if you're looking at the question of whether fault is to be attributed to Primeo for not raising this point specifically in its closing submissions, it has to be seen in that context. But I mean, that I would submit is perhaps the cherry on the cake, because ultimately the question is you have to ask yourself, well, why is the Court of Appeal's approach to this wrong? In our submission, it's very difficult to see why it is. So that's the loss of a chance argument. As we say, the Court of Appeal was exactly right to approach that in the way in which they did. The second ground is that the respondents then say that the Court of Appeal erred in overturning the judge's conclusion that the directors would have reinvested monies withdrawn from bill miss.
Can I just ask? I mean, loss of a chance is a topic that tends to come up in other contexts. For example, medical negligence, and or personal injuries law more generally, and it's a rather tricky topic. Anyone who's tried to make sense of Gregg and Scott as against Hodson, will know that. I mean, this approach is really saying that if you have this is a different use of the expression loss of a chance. It's saying if you have a chain of causation and there's an element in the chain which you can't prove on a balance of probabilities, if it depends on the actions of a third party, it's nevertheless possible for you to succeed in your claim on the basis of a percentage probability, as I understand it.
That's right. So you can establish causation on that basis, and then there's a question of quantifying the percentage. Yes.
Has this approach been applied, or for example, is there any authority at this level that has approved or applied that approach?
I don't know off the top of my head. I mean, obviously, Allied Maples is.
Yeah, well, Allied Maples, I see
Court of Appeal, although it's
in Westlaw, it's got scare marks around it.
Yes.
Mixed judicial consideration.
I see. Well, I don't think a point's been taken against me that Allied Maples isn't the law. I mean, that was plainly the law. I think that was cited by both parties to the Cayman Court of Appeal. It's a point they take. I don't think there's a point taken on this appeal that it's wrong. I mean, just for your lordship's reference, I mean, there is quite interesting authority. I think we've included a case in the bundle called Asset Co. In the case of auditor's negligence, and one of the points that case makes is that way of looking at causation isn't just permissible, but it's actually mandatory, because you may have a claimant who wants to avoid loss of a chance causation because he wants to actually not have his damages diminished. He may actually come to court and say, well, although my chain of causation involves the acts of a hypothetical third party, I want to prove it on balance of probabilities, because if I do, that gives me a larger pot of treasure at the end of the day. And the courts have said, and this was the judge, he was upheld by the Court of Appeal on this point, is that no, that's wrong. If you come to the court seeking to prove your case on balance of probabilities, but actually the correct legal analysis is that because your chain of causation involves the acts of a hypothetical third party, you have to apply loss of a chance causation.
Yeah. I mean, Asset Co. That's a rather interesting illustration, because as you say, it's to do with a negligent audit.
Yes.
And it was a Samco argument, and so the judge was having to look at the counterfactual of a proper audit, and deciding what would then have happened. And he found the likelihood of the outcome that he was looking at was 90%. In fact, over 90%.
Yes.
And so he said, well, that's been proved. And the argument on appeal was he should have discounted by 10%.
Yes.
Because it wasn't a 100% certainty.
Yes. Well, exactly. I mean, that's how he came to it on the...
and that was rejected. The argument was rejected.
On the figures, yes. I mean, the bit... just whilst we're here, if you go to 2732, I mean, the passage I had in mind is paragraph 411.
I'm sorry, what was the page?
2732. It is in my estimation a useful case because this paragraph actually follows a quite lengthy exposition of the law in this area. But the particular point he's focused on is the point I was just describing, which you see in 411.
Well, of course, he's bound by Allied Maples.
Yes, I mean that's certainly true. And he, as you see in 411, essentially that's the point I was just making. It's not permissive; it's mandatory. And then, as your lordship rightly says, there's then the issue they had in that case about what the actual percentage loss of a chance would be.
Yeah.
But I think for the purposes of this appeal, it's not being suggested that Allied Maples isn't the law. As I say, that's the way it was put in the Court of Appeal. The respondent's case doesn't seek to argue that decision is wrong or it doesn't reflect the law. So I was going to go then to the reinvestment argument, which, as I say, is the other, I think, principal element of the respondent's argument on causation. They say that the Court of Appeal erred in overturning the judge's conclusion that the directors would have reinvested monies withdrawn from Bilmes into another Madoff fund. And the respondent's first point in relation to this was to say that the Court of Appeal was wrong to find that the judge's conclusion was premised on Primeo successfully obtaining what's been referred to as a post-withdrawal audit opinion, and that there was no evidential basis for that premise. Now, the starting point is the Court of Appeal judgment at 339, which is page 309. And the first point is that the Court of Appeal were right at 339 to find, as they did, in the third sentence, that the judge's conclusion was based on an assumption. So that was, in our submission, plainly right. They were right to identify that assumption, in the terms they state it, underpinned the judge's reasoning. Now, the second point is that what the Court of Appeal holds in paragraph 340, sub 1, is also, in our submission, undoubtedly right. That there was no evidence on this point. And that paragraph, we submit, is undoubtedly correct as a statement of the evidence which was before the court. Now, before your lordships, what my learned friend seeks to do is to support the judge by what is said to have been implicit in the fact that Primeo was advancing a loss of profit claim in conjunction with advancing the case on auditor causation. And I think he says, well, that provides some sort of evidential basis for the judge's approach. Now, there's three preliminary points we'd make about that. First of all, of course, the loss of profit claim was in fact rejected by the judge and indeed was not ultimately advanced before the Court of Appeal. Secondly, when the judge was considering that aspect of the case, he didn't in fact find that such an audit opinion could have been obtained. He deals with it in two places in his judgment, and you need to look at these quite carefully. The first is paragraph 259, E144. It's the final sentence which your lordships looked at before. He doesn't make a finding in that final sentence. All he's saying is what is implicit in the argument. And the other place he deals with it is 267 at E146. Um, 267, sorry. Paragraph 267. And it's the penultimate sentence, well, the antepenultimate and penultimate sentences. And what matters are the opening words of the penultimate sentence. Even if this is right, he doesn't actually make a finding. So that's the second point. The judge actually doesn't make, as well as dismissing the loss of profits claim for various reasons, he didn't actually make a finding that as part of that claim.
Can I just be clear? Are these passages in the context of the judge's rejection of your loss of profits claim? Is that what they're directed to, or is it wider than that?
They're potentially wider. The reason I point to them, these are the only passages where he deals with the obtaining, he deals with the question of whether a post-withdrawal audit opinion could have been obtained. And the reason for referring to them is this is where the judge deals with that point. And just to make the point, he doesn't actually make a finding on it. He's just referring to what might be said to be implicit in the argument, even if this is right, is the formulation he uses in 267. Thirdly, there also, as I've already submitted, wasn't any evidence addressing this point. The Court of Appeal was right in what they said about that at paragraph 340 sub 1. Now, in our submission, it's untenable to say that a point which might arguably be implicit in a claim which was rejected by the judge and which was not addressed in the evidence can be said to provide evidential support for a different part of the judge's analysis. I mean, that's what my learned friend's argument in effect amounts to. And in our submission, that isn't a tenable proposition. What might be said to be implicit in an argument or a claim that's rejected isn't evidence that provides support you can then use as a building block for a different part of the forgive me, just on that, the judge might not have thought there was a dispute about it. If you were positively advancing this view of the facts for the purposes of your loss of profits claim, and you weren't distinctly saying, but if I'm wrong about that, there's this alternative claim, the judge might have thought, well, there isn't a dispute. Well, we weren't
that's how to analyse it.
Well, we weren't expressly advancing. I think this is something, as the judge said, he regarded as being implicit. But it certainly wasn't anything that was being expressly advanced. But it's also, in our submission, a bad point for a further reason, which is this. The loss of the profits claim was not premised on Primeo investing in other Madoff funds. The loss of profits claim was premised on Primeo investing in entirely different funds, unconnected with Madoff. And you see that, I'll just give you the reference to the investment expert's report. It's in the second supplemental bundle at page 7.
Sorry, the reference again.
Second supplemental bundle at page 7.
But I thought Mr. Gillis explained that to us. But what he was at pains to try to bring out was that in order to mount your loss of profits case on the basis you've just mentioned, you needed to have as a step in the reasoning that EY would have given a post-withdrawal clean audit opinion.
But that's my point, is that the loss of profits claim, though, is premised not on investing into other Bill Miss Madoff feeder funds, which is the judge's finding.
Yes.
It was based on reinvesting into entirely unconnected funds, bona fide.
That's what I've just put to you.
Yes.
But in order to get to having the money in your hands to reinvest in other non-Bill Miss funds,
yes.
Primeo needs not to have been wound up. And in order not to be wound up, you need a post-withdrawal clean audit opinion of Primeo from Ernst & Young, don't you?
Yes, but the point I'm making is that the fact that Primeo say, for the sake of argument, might have been able to get that audit opinion where it had somehow withdrawn and transferred its investments into non-Madoff funds, doesn't tell you that Primeo would have been able to get that audit opinion if it had somehow managed to transfer into bill miss funds, which is the judge's approach. Because if Primeo had still been invested in bill miss funds, you would have had exactly the same concerns about bill miss, which led the EY not to be willing to give the audit opinion in the first place. So my point is simply that the fact that if you're in a world where you've successfully withdrawn and invested in the sort of funds we see here, which the investment experts were looking at, Vanguard, iShares, ETF, well, fine, you get an audit opinion having done that exercise. It doesn't mean that if you've now reinvested it doesn't mean that in the other scenario where you've reinvested into bill miss through these other feeder funds, you'd be able to get an audit opinion, because in that scenario, you're going to have exactly the same concerns from EY that you had in the first place. So, I mean, the point is that there is a non sequitur in this anyway, because it's not the same scenario. So 2 points we make in relation to this. I mean, firstly, there isn't any evidence, and the Court of Appeal was right in the way they approached it, and you can't take what's implicit in an argument. You can't take what you might regard as being implicit in an argument that is rejected as being a building block for different parts of the analysis. But secondly, it doesn't work anyway, because you're looking at different scenarios and the one doesn't translate to the other. Now,
I'm so sorry to take up time on this, because I didn't understand, I'm not understanding this submission. As I understand it, looking at paragraph 267 of the judge's judgment, the chain of reasoning which the judge is trying to follow through, which at the moment, as I understand it, is a chain of reasoning you were inviting him to adopt. Well, all right, you weren't inviting him to adopt, but he's identified it as implicit in your case, is that in order for the loss of profits claim to work, one needs to be in a position after the custody confirmations have been received by Ernst & Young, that they're still willing to give a clean audit opinion on Primeo. Because if they don't, Primeo as a fund will have to notify the regulator, and indeed repay. People won't be happy investing in an investment fund which doesn't have a clean audit opinion. So they'll have to return monies to clients, and therefore won't have money in their hands to invest to make the profits which you're seeking to claim. So in order, after 2005, to be for Primeo to be in a position to have money in their hands, which they've removed from bill miss and now want to reinvest in non-bill miss funds, they need a clean Ernst & Young audit opinion on Primeo's accounts as at, I'm not sure what the year-end date is, but 2005 or thereabouts.
Yes, they need that at some point. And
sorry, and this is what's in my head, and you can tell me why I'm wrong. And to get that, the judge has said, well, they don't get it on the basis of the custody confirmations, because Ernst & Young not happy with those, but they might have got it on a post-withdrawal basis if the cash had come in, representing the value of the assets at the balance sheet date. And it would have been legitimate audit evidence, although there was no evidence about this, but this was, we're told this is implicit in the argument, such that there was a clean Ernst & Young audit opinion on Primeo, which means Primeo can keep that money in its hands, doesn't have to return it to clients, and then invest it in non-bill miss funds and make lots of profits.
Yes, and my answer to that is you can't just look and pause the situation at where the cash has been received, because post the receipt of the cash, there's two different scenarios. The loss of the profits claim assumes that the cash comes in and you invest it in Vanguard, say. The judge's scenario assumes the cash comes in and you effectively invest it back into exactly the same place where you had the concerns in the first place, whether your auditors had the concerns in the first place. And my point is there's a fundamental difference between those two scenarios, because your auditor may, on the loss of profits claim be willing to give you the audit opinion because you've got the cash back, you've then reinvested into a fund about which it can have no possible concerns, it's willing to give you your audit opinion. If, on the other hand, what's happened is you've got the cash back, but you've then put it back in exactly the same type of fund where the auditor's been telling you we've got concerns about whether or not the assets exist, well, why is the auditor going to give you the opinion in those circumstances? And so my point is just that the two situations aren't the same, and you can't.
They're not identical, but surely what motivates the post-withdrawal audit opinion is the fact that the cash value of the assets, which were said to be there, had been realised and paid to the fund. Well, and that in the case of investing in other funds gives reassurance to the auditor that Wilmus had the money. Yeah. In the other case, putting it back in Wilmus, yes, there is a distinction in the sense that the money is going back into somewhere that you've had doubts about. But the very fact that there had been a successful withdrawal, would that not make it likely that the auditor would say, fair enough, they produced the goods?
Well, in my situation, no, not if you're putting it back into in effect exactly the same place where the auditor has been telling you we've got concerns about whether the assets exist. So, I mean, what that presupposes is you sort of, I mean, it's a little like sort of month-end window dressing in the sense that you get the cash back into your account for a day and say, well, look, here's the cash, give me an audit opinion, and then the next day send it back into exactly the same situation where the auditor's been telling you I can't verify the assets exist. I mean, in our submission, you can't draw the conclusion that the audit opinion would have been forthcoming in those sort of circumstances. In our submission, it's unlikely it would have been.
But you say that to us now,
yes,
for reasons which I understand, but at the time of the trial, in order to advance your loss of profits case, yes, didn't you have to be asserting that there would have been a clean audit opinion? Because otherwise Primeo would have come to a shuddering halt in 2005 and wouldn't have made the additional profits which you were claiming.
But this is the point I'm seeking to make is that the loss of profits claim is based on a fundamentally different scenario because you're
that's what I think you're growing towards. But
yes,
if you could answer my question
yes,
directly first, for your loss of profits claim, wasn't it a necessary part of your case that there would have been a clean Ernst & Young audit opinion on Primeo in 2005?
Yes, I think that that is implicit in the sense that without that you're not in a position to reinvest at all. No, I accept
so you can't make the profits, right?
So
does it come to this, that what you're criticising the judge for is failing to differentiate two actually completely alternative ways of putting your case on damages? You have your loss of profits case, which is predicated on an Ernst & Young clean opinion in 2005.
Yes.
And then I've forgotten what label we're using. The
withdrawal and future investments. Yes,
future investments,
exactly.
which isn't predicated
exactly
on that. But then isn't the question then whether you sufficiently alerted the judge to the fact that for the purposes of your loss of profits case, you were positively relying upon Ernst & Young having produced a clean audit opinion in 2005. You've accepted that's a necessary part of that argument. But against that background, you sufficiently alerted the judge to the fact you were running a completely separate argument, which begins, and of course, Ernst & Young would never have issued a clean audit opinion in 2005, and we'd have withdrawn our assets.
Well, I think a number of points in relation to that. Firstly, it was made very clear to the judge that the loss of profits was an alternative claim. We can give your lordship the reference to our closing submissions on that. That was made clear. Secondly, your lordship's right to say, if you look at the logic, you can regard that assertion about the audit opinion as being implicit in our loss of profits claim. It was not a point that was ever made expressly. It's effectively a point that the judge drew out of the logic of the argument.
You have accepted the logic of the argument.
Yes, and then thirdly, they're obviously completely different scenarios because the loss of profit claim as I say, is assumed and was very clearly put on the basis that the reinvestment would be into actually Vanguard and iShares, were the two mentioned at page 7 of Supplemental Bundle 2. Whereas the judge's theory on the obtaining of the post withdrawal audit opinion is based on a reinvestment into exactly the same sort of funds from whence there was the problem. So in our submission, I mean, ultimately it's a question of what is the evidential basis for the judge's conclusion in relation to the post-audit withdrawal opinion.
One might say there's a bigger problem, and that is what is the evidential basis for either of the counterfactuals you put forward, because you had no evidence at all from anyone in Ernst & Young as to what would happen. I mean, this is all building counterfactuals on what might be described as speculation.
I mean, the reality is, as liquidators, we're not in a position to compel the auditors to give evidence. We sought information.
But you can have expert evidence. I understand you.
Yes.
Ernst & Young might be deeply reluctant to come along.
Yes.
For various reasons, but that's when you have expert evidence. Say, well, what would auditors have done in this situation?
Yes, but I mean, I think I'm not sure why. We've established causation. I mean, the causation argument simply put on the facts, which we submitted were ultimately uncontroversial, that you could see the auditors had problems. You could see from the documents what they were saying needed to be done. And the question was, well, if they hadn't been given the custody confirmation, would they have been provided with would they have provided a clean audit opinion? Now, that was a position we were able to deal with on the facts. It was dealt with before the judge and before the Court of Appeal on the facts successfully. And the question simply was, well, was there a real and substantial chance that Ernst & Young wouldn't have given an audit opinion?
I'm lost at the moment as to why you can rely on loss of a chance in this context when you're in a position to lead evidence and you don't. You're leaving it to the judge to speculate.
Well, with respect to that, I mean, as we understand it, loss of a chance it's not optional as a tool of assessing causation. I mean, either the acts involve the acts of a hypothetical third party, or they don't. If they do, then, as we understand the law, you apply the loss of a chance test for working out whether causation
may or may not be the law. In looking at it, there's an issue about that, I think. But assuming that it's a law, because it's not being challenged in this appeal, there still has to be a proper evidential basis for a judicial assessment of probability.
Yes.
Now, so what's the evidential basis for assessing probability in this case?
Well, all the material that we have, the evidence of the documents which we obtained from Ernst & Young through the procedure I referred to earlier in August 2006, their audit papers, the documents that originally adverted us to the existence of the custody confirmations. I mean, there's all the material that shows the history of this episode as it developed and how it was resolved. Now,
was there any expert evidence as to how a reasonable auditor would react in the scenarios that you put forward?
Yeah, because this is a counterfactual scenario.
Yes.
Yes.
So evidence about the factual scenario doesn't get you home, I wouldn't have thought.
Well, you have to... no, I mean, answer to the question, no, there wasn't expert evidence on the audit point. It is a counterfactual scenario, but the counterfactual is obviously informed by what you know about what the auditor is saying, what its attitude is, what its approach is. And it's not... the other point one could legitimately make about this is this is not a commoner's garden audit problem. It's not a sort of issue that arises regularly in audits and someone can come along and say, well, yes, we come across this all the time and this is how an auditor would deal with it. This is an intensely unique problem related to Madoff, where you've got the auditor concerned about fraud. And then you see what happens. It's resolved in a rather unusual way, where you get this custody confirmation issued. So it's a very, very bespoke situation. I mean, the other point I would make in relation
I think that was all the more reason why the judge would need the assistance of expert opinion evidence.
I mean, the other point this is I'm slightly getting diverted given we've got very limited time, but I mean, the other point I would make on it is just what the Court of Appeal said in Allied Naples about proof. And they made the point, yes, it's at the bottom of bottom of 2556 on 1614. And I mean, what they're saying there is, well, where you're dealing with a hypothetical, which by definition you are, then often the attitude of the third parties is going to be a matter of inference. In many cases, direct evidence from the third party will not be available. In our case, we didn't have evidence available from the actual auditor, Ernst & Young. But I mean, going back to the point I'm actually on at the moment, I mean, the question is whether whether the Court of Appeal was right to say that there wasn't an evidential basis for the judge's assumption that a post-withdrawal audit opinion could have been obtained in circumstances where you're withdrawing and reinvesting into another bill misfeeder fund.
But I mean, there might not have been an evidential basis. I follow that argument, but it might not have been an issue. I mean, judges resolve things which they understand to be an issue.
Well, it was in issue in the sense that this is my learned friend's argument ultimately, isn't it, in relation to the reinvestment? I mean, it's his argument to say, well, look, you don't establish causation because you may well have got the money out, but actually you'd have put it straight back in. So I mean, that's my little friend's argument. It's his argument to say that's why you don't establish causation.
Well, he's taking your argument in relation to the lost profits, which you have accepted here, and the judge rightly identified as involving the implicit assertion that Ernst & Young would have issued a clean audit opinion.
Yeah. But I mean, we're back to the same point. As I said, that I mean, A, that's not how it was put. And B, there isn't any, those are different scenarios because you're talking about reinvesting into entirely different positions.
Right. I mean, they're different scenarios.
Yes.
But people, for tactical reasons, sometimes don't make an issue of different scenarios. You would get more damages if you succeeded in your loss of profits case. I haven't looked at the figures, but I imagine that's why you were running it. In which case, for tactical reasons, it would not have suited you to emphasise that there's no way Ernst & Young would ever have issued a clean audit opinion on Primeo, because that would have torpedoed the case that you wanted to win on.
Well, I mean, that's not how it was put to the judge. I mean, if you look at the material, there's a large amount of time devoted to causation. Loss of profits is treated as part of quantum. I don't think we made any submissions or arguments, or indeed led any evidence on the question of how causation worked in relation to loss of profits.
I don't want to take up more time on this, but could we in due course have the page bundle references to where your case was put to the judge
on loss of profits?
Well, yes.
Yes, yeah, we will. We'll make those available.
Indeed, loss of profits, and indeed how that related to your withdrawal argument as well.
Yes,
insofar as you can, just so we can see.
Yes, we'll pull those together, my lord. Just moving on very quickly then, the respondents, the other point they make on this is to say there were other auditors who worked with Madoff feeder funds who might have been willing to give a post-audit withdrawal opinion. There's no evidence as to the likely position of other auditors. There's no reason to think that PwC, for example, would have been any more willing to give a post-withdrawal audit opinion than EY. And the other important point in relation to this is any replacement auditor would necessarily have been engaged in circumstances where the previous auditor had resigned. By definition, one is in a situation where EY have said, we're not prepared to continue as auditor. And we would know the reasons for that is they're concerned about whether the assets exist. They haven't been able to be satisfied on that. And the question is, well, is there any basis for saying that a new audit firm would have come in that either it wouldn't have been told that, or if it had been told that, it wouldn't have cared, and it would have issued an audit opinion? I mean, nothing to suggest that at all. The other point on this is the question of reinvestment in another feeder fund, and whether the directors would have done this. This point only arises if the Court of Appeal was wrong to overturn Mr. Justice Jones' finding that Primeo could have obtained a post-withdrawal audit opinion. If the Court of Appeal were right about that, you don't get to the second stage, which is to ask, well, what would the directors have done? And that's because, obviously, unless Primeo obtained an audit opinion, it couldn't have carried on business as a mutual fund. But assuming one gets over that hurdle, well, the question is, well, what would the directors have done? And you're in a situation where the fund's auditors, to their knowledge, had refused to provide an audit opinion, absent independent confirmation of the assets. The confirmation hadn't been forthcoming. As a result, the fund had withdrawn its investments from Bilmis. And the hypothesis is that directors, knowing all that, would simply have sent the investments back to, in effect, exactly the same place where the auditors had told them, we can't confirm the assets exist, and we're resigning, and we're not prepared to provide an audit opinion. And on that point, in our submission, the Court of Appeal's conclusion at subparagraph 4, paragraph 340 was correct. Now, the third argument in relation to causation is what's called the wrong counterfactual argument. The argument is that the Court of Appeal should not have asked itself the question of what would have happened if the second respondent hadn't issued the custody confirmation. It said that the Court of Appeal should have applied the same counterfactual as it did in 2002, namely, would Primeo have agreed to amend the administration and custody agreement? In our submission, this is wrong also. As a starting point, but for causation is obviously looking at the position but for the breach. You're asking yourself, well, what would be the position if the breach hadn't taken place? That is how the judge approached it. If you see paragraph 260 of his judgment, page 144 of the electronic bundle, where he deals with this point, and this is in the context of causation. First sentence of paragraph 260, he approaches it correctly, we submit, on the basis that HSSL ought not to have issued the 5th of April 2005 custody letter. Now, that's also how the Court of Appeal approached it at paragraph 318, Roman numeral 1, page 300 of the electronic bundle. Now, my learned friend, I think, for the purposes of this argument, concentrates on the language which you see in parenthesis in 318, subparagraph 1. Where reference is made to it being a consequence of the breach. But it's clear from what the judge says at 260 that what he means is that in circumstances where no recommendation as to safeguards has been made and no safeguards put in place, that the custody confirmation should not have been issued. And when he says at 260, I agree with the proposition that the second respondent ought not to have issued the custody confirmation. That is because no safeguards have been put in place, no recommendation have been made, and there's no way on which the second respondent is therefore able to corroborate or confirm the information which is providing to the auditor. So in that situation, one does have to ask oneself what the position would have been if the custody confirmation had not been issued. Now, apart from that, the position, as I submitted earlier, April, May 2005, was factually different from that as at August 2002. And it's incorrect to suggest that one can simply apply the August 2002 position to April, May 2005. At August 2002, there was no issue with the auditor, no issue in relation to the provision of custody confirmations. And the judge held at that stage, well, if the second respondent had performed its duties properly, then the most likely outcome was that Primeo would have agreed to amend the custodian agreement to remove R2's responsibility for the assets. The Court of Appeal effectively agreed with the judge on that point. The position is fundamentally different by April 2005. You have now the auditor, Ernst & Young, making it clear that they won't provide a clean audit opinion on the accounts without confirmation as to the existence of the assets from a third party, that they're not prepared to rely on Bilmis's own auditors, Freeling and Horowitz, and that unless the position is remedied one way or another, they're going to resign. Now, in those circumstances, the findings from the earlier 2002 date plainly don't carry over. And you can't simply take what the judge concluded in August 2002 and say, well, that is what would have happened in April, May 2005. The debate in April, May 2005 was fundamentally different because it was all concerned with getting the accounts signed off and getting a clean audit opinion. And fundamental to that was the provision of the custody confirmation. The judge said the custody confirmation shouldn't have been provided. Well, what would have been the position if it hadn't been provided is the question. Now, the other point one would make in relation to this is the respondent's counterfactual is also implausible, doesn't have any foundation in any evidence as well. It posits a counterfactual where the directors of Primeo and the respondents know that independent confirmation of the assets at Bilmis is required by the auditors, that they then agree to amend the second respondent's custodian agreement so it has no responsibility for those assets. And on that basis, the second respondent then gives a custody confirmation without having carried out any checks or confirmations to enable the auditors to sign off the accounts. Now, in our submission, that would involve clearly inappropriate conduct on the part of both the directors and the respondents. It basically amounts to saying, well, we know the auditors want the independent confirmation. The workaround is that we're going to make the second respondent not liable for anything. And in return for that, the second respondent will give a confirmation without checking anything. And then we can give that to the auditors and they can sign off the accounts. There is no basis for concluding that they would have acted in that way. My little friend sought to make some submissions in relation to the position of another investment fund, Alpha. That doesn't assist either. The Alpha custodian agreement was actually entered into in 2003, before Ernst & Young had raised any issues at all in relation to Bilmis, as to whether the assets really existed and so on. And it's not therefore evidence in any way that Primeo's directors would have amended the custodian agreement in response to Ernst & Young's concerns about Bilmis, in order that the second respondent could then issue a custodian confirmation to Ernst & Young to enable the accounts to be signed off. So that's the wrong counterfactual. The final argument is what's called the R1 loss of a chance argument. My little friend didn't pursue this orally, so likewise I'm not going to deal with it orally. To the extent it's still alive, it's dealt with in our reply case at paragraphs 80 through to 86. So there's then the remaining grounds, which I'll obviously deal with briefly, like my learned friend. The first of these is the meaning of agent in section 37 of the limitation law. This is additional ground 8. And the Court of Appeal dealt with this in our submission entirely correctly at paragraphs 453 to 458 of their judgment. If we can just bring up the text of the Limitation Act, it's section 37(1), 9486. And this particular point focuses on the last sentence of subsection 1. References in this subsection to the defendant include references to the defendant's agent and to any person through whom the defendant claims and his agent. And the question, in short, is, well, what does agent mean in this context? Now, in our submission, it's necessary to take a little care to identify what the issue actually is, so far as this case is concerned. In our submission, the issue arises where you have one party, Party A, which owes a contractual duty to Party B to perform a certain function or to provide a certain service. A and B then agree that the performance of the function or service required under the contract can be undertaken by C in discharge of A's obligations, but that A will remain responsible and liable to B for such performance being as required by the terms of the contract. So that is essentially the issue that arises so far as the present case is concerned. And the question is whether the reference to agent in section 37(1) encompasses someone in the position of C. So in other words, a person who is appointed to discharge and perform the obligations of another party under a contract. Now, in our submission, the answer to that is yes, as the Court of Appeal held. If we just look at the facts of the present case, Bilmis was authorised by the second respondent to act on its behalf to perform its duties under the custodian agreement with Primeo. That was the effect of it being appointed under Clause 16b. Bilmis's acts in this respect affected the second respondent's legal relations with Primeo, either by discharging its contractual duties to Primeo, or, if such duties were not discharged, as required by the terms of the contract, by exposing it to liability to Primeo for breach. And just pausing there, my learned friend says, well, one of the touchstones is whether the acts of the agent affect the principal's legal relations with the third party. Bilmis's acts plainly did affect the legal relations of the second respondent with Primeo, either because they discharged an obligation of the second respondent to Primeo, or because they would expose the second respondent to liability. Now, the respondent's approach is essentially to construe agent as simply being confined to a person who is authorised to enter into new obligations on behalf of its principal. So they characterise and confine an agent essentially as meaning someone who is appointed on behalf of his principal to enter into a new obligation. But in our submission, there isn't any reason to confine the meaning of agent in that sense. It can equally include someone who is appointed to perform a contractual obligation owed to another party. That person is equally an agent. He's the means by which you perform and obtain discharge of your contractual obligation. Now, in our submission, this approach makes sense as a matter of policy. Where performance of a contractual duty is delegated for performance by another party, then it must be the conduct and state of mind of that latter party which is relevant for the purposes of section 37(1). Indeed, the conduct of the party, the conduct and state of mind of the contracting party is irrelevant, since it's not the party performing the contractual duty. So in that sort of scenario, if you're looking for the party whose state of mind is relevant, it must be the party who's actually performing the obligation. And the Court of Appeal made this point at paragraph 457, page 352. It's the bottom of 352 and then over onto 352. Mr. Gillis was unable to offer a justification for treating the knowledge of a person or entity which has a contractual task or part of a contractual task delegated to it, but who fraudulently conceals its breach as attributable to the person or entity which delegated the task when the delegate is an agent, but not when it is an independent contractor.
Is there any discussion of this in textbooks or commentaries of this agent point?
Yes, so indeed there's the two authorities on the point, which are Applegate and Moss and King against Victor Parsons, which both support our construction of it. And I wasn't going to take you to those. I mean, they're both very similar facts. So both concerned a situation where a developer had agreed to sell a house to a purchaser and then arranged for a builder to build the house in order to perform his obligations under the contract with the purchaser. So it's exactly the type of situation I've been describing. And in both those cases, it was held that the builder was the, quote, agent, unquote, of the developer for the purposes of what was 26B. It's also referred to, the point is, those cases at least, and the point is also referred to quite extensively in the textbooks. And if you go to paragraph 102 of our reply case at 2344, we set out some of the main references. So it's not an unknown point. I mean, you'll see these are the in effect the mainstream textbooks. So in our submission, ultimately, King and Victor Parsons, Applegate and Moss are right. The Court of Appeal was right. It remains the law. Now, so far as contributory negligence reduction is concerned, I'll deal with the position against the first respondent and against the second respondent separately. So far as the first respondent is concerned, the judge decided that Primeo was contributory negligent to a level of 75%. The Court of Appeal held that that was wrong and outside a reasonable range, and that the appropriate level of reduction was 50%. If your lordships are against us on our appeal and so hold that contributory negligence is capable of applying in principle to the claim against the first respondent, then our submission is that there is no basis, no proper basis for interfering with the Court of Appeal's conclusion on a 50% deduction. The key part of the Court of Appeal's judgment is at paragraph 507, page 370. Where they effectively summarise their conclusions on the point. In our submission, it was plainly right for them to take into account that the first respondent was a professional service provider and that it had been engaged under the administration agreement for the specific purpose of providing fund administration services to Primeo. Put another way, the first respondent was the expert fund administrator. It was engaged for that purpose. Its contractual duties included producing and issuing the net asset value for the fund, the NAV. And that was plainly a relevant factor.
But are you saying that the judge hadn't taken that?
Yes, well, if you look at, I was going to come to 319 of the judgment. If you look at...
Because if I may say so, you're starting with the Court of Appeal's approach,
yeah.
But don't you have to satisfy us that they were right to interfere with the judges?
Yes. Well, if we look at the judge's reasoning on this, which is what I was going to go to next, E178. I mean, he doesn't deal with this point at all, which is probably the starting point, which is if you're undertaking an evaluative assessment of the relative culpability, the relative responsibility of the professional versus the client, the starting point, and indeed we would submit the factor that deserves most weight, is that the professional is the person engaged to carry out the service, that the professional is the expert, and that the professional has an express contractual duty to carry out that service. That is the starting point and the weightiest factor. Now, if you look at 319, and I think this is a point my Lord Sales made yesterday, that does not feature anywhere. He approaches it in a entirely one-sided way of saying, well, look, this is what Primeo knew, this is what Primeo was culpable for, so on and so forth. There is no counterweight to that. And it's not just a question of counterweight, it's actually starting point of asking yourself, well, what is the weight attached to the fact that this is a professional engaged to provide a professional service? And you can test it. I mean, if you're talking about contributory negligence in relation to a lawyer, an accountant, a doctor, surely you start with the fact that you've engaged a professional to provide a service and that you're reliant to a lesser or greater extent on their expertise. Now, the other factors which the Court of Appeal identified, but which the judge didn't identify, so this involves looking back at 507 of the Court of Appeal, is it was relevant that the first respondent had failed to make Primeo aware of HSBC's own internal concerns. I think when my learned friend dealt with this point yesterday, he may have slightly misread what's in 507, because the point the Court of Appeal was making in that part of 507 was that what was relevant is that Primeo was not aware of the fact that within R1 and HSBC internally, these concerns were being expressed. So within the effectively the ambit of the respondents, that there was discussion and exchanges about the concerns. The point isn't about Primeo's knowledge of what's called triple function and single source reporting. It's the fact that within HSBC, if I can use that term, there were these concerns being expressed about exactly those issues, and including ultimately the risk the assets didn't exist. Now, the other point in relation to this is the respondents are light on the statement in relation to monitoring, which is one sees in the second sentence. We do so in light, particular fact that R1 was performing professional service, was given the specific task of monitoring bill miss. In our submission, there's nothing in that point either. Although it's important, although we have the two legal entities, R1 and R2, your lordships may appreciate that in practice, the functions of R1 were carried out by R2 under a delegation agreement. So although legally we have the two entities, in practice, it was all done by R2 because it was effectively delegated to them under that agreement. And the responsibilities of R2 plainly included monitoring bill miss. That was clause 16B of the custodian agreement. Now, the position in relation to R2 itself is different. The judge held, as you know, that contributory negligence didn't apply to the claims against R2, and he didn't address the position on the contingency. He was wrong about that, so he didn't deal with the level of reduction. The Court of Appeal didn't expressly address the level of reduction, although they did conclude wrongly we say that contributory negligence applied in principle to the claims against R2. However, we agree with the respondents that it's probably implicit in the Court of Appeal's judgment that they considered the level of reduction to be 50%. They don't say that expressly, but I think one can probably infer from the fact that they say contributory negligence applies and that they don't state a different figure, that they were considering it ought to be 50%. Now, in our submission, Your Lordship shouldn't interfere with that decision for the same reasons we gave in relation to R1, but also for the further point that actually this was an issue considered for the first time by the Court of Appeal. It's not a case, actually, where the Court of Appeal were overturning the judge. The Court of Appeal had to consider the issue, and they did. Now, alternatively, if we're wrong about that, and Your Lordships are minded to revisit the question of the reduction, then the question is, well, what is the appropriate level of reduction? And we deal with that in our reply case. I'll just give you Lordships the references given the time. But it's effectively paragraph 138, and the points which we make in support of that are essentially the points we'd set out in our original written case at 95 and 96. As I say, our primary submission is ultimately, well, the Court of Appeal should stand on both points.
But if it's just on the Court of Appeal in relation to R2, I can see that they're the first court that's actually made the apportionment. Yeah. But if their implicit reasoning is, well, it should be the same, and if they were wrong to overturn the judge at 75%, so that if they had properly said, well, judge said 75%, we accept that, views might vary, but the responsibility of R2 is the same, wouldn't the logic of their own reasoning then be to apply 75% to R2 as well?
Well, I mean, not necessarily. I mean, what we don't know is, because it's not expressed in the Court of Appeal judgment, is what the reasoning is, if any, that underlies the reduction for R2. I mean, they don't deal with it at all. I mean, it's a matter of inference to say, well, it's...
But you've drawn, isn't it a bit revealing? You've both drawn the inference that they intended it should be the same.
Yes, but I think then to go the stage, if I may say, if you go the stage further and then draw an inference on an inference and say, well, the reasoning behind that is X, Y, Z, I would respectfully suggest is a stretch. I mean, you can make, and there are in our submission, correct arguments as to why the position of R2 is different from that of R1. I mean, R1 is engaged on the service to produce the NAVs fundamentally. R2 is engaged to safekeep the assets. Fundamental contractual duty to safekeep the assets. And it doesn't, in my submission, follow that the reasoning in relation to R1 would just translate across to R2. I mean, my point was perhaps more a sort of procedural point rather than a point based on equivalence of reasoning, in that I was making the point that if, given the Court of Appeal has dealt with this in relation to both of them, then the appropriate, and then there's no reason to think the Court of Appeal's approach is wrong, then the appropriate course is that your Lordship shouldn't revisit the question. If you do revisit the question, we say that the reduction in relation to R2 would be zero for the reasons we've outlined. So that's contributing negligence reduction. I think that just leaves me 2 minutes, but that may be all that's required. There's just two remaining points. One is assignment. It's an entirely new point. It's never been raised before. It's not open to the respondents. It's also a bad point. you just need to look at the written instructions that set out the terms of the transfer. There are E876, E877. Plainly, on the face of those written instruments, there isn't an assignment of any rights of action of Primeo against the respondents. The implied agreement argument, we respectfully submit, is hopeless because there's simply no foundational basis for it. Amongst other things, not only is there no evidence to support it, but there's also no basis for thinking that the parties would have intended to assign these rights. Their commercial purpose didn't require such an assignment. There's no reason to think they were intending to do so. And in fact, on the contrary, after the transfer, Primeo was continuing as a fund and continuing to have its administrator and custodian who remained the same. So why would Primeo have transferred rights against that administrator and custodian to a third party? So far as capacity in which losses suffered, ultimately, we'd say this raises essentially the same issue as we were discussing in relation to strict liability. We've set out certain points in writing, but I don't think I need to spend time elaborating those. So I think just falling within my allotted time, unless your lordships have any questions for me, those are my submissions.
Thank you very much, Mr. Smith.
I'd like to start by making a few observations in respect of assumption of responsibility. So that's ground 3 of my learned friend's appeal, and connected comments in respect of causation, loss of a chance. So those are two of the themes that are connected by the principle of finality of litigation. On assumption of responsibility, really just one factual point in response to what my learned friend said. My learned friend, in response to Lord Sales, said that there was no time to put in further evidence on its quantum case. That's not so. Just to put it in context, the trial started on the 7th of November 2016. Mr. O'Neill gave his evidence on 18th to the 21st of November 2016, and that's when he crashed and burnt. We didn't sit for 2 weeks over the Christmas holiday, and the quantum expert evidence cross-examination didn't start until the 27th of January 2017. So if they wanted to put in further evidence, quantum evidence in respect of their assumption of responsibility case, they could have done so. And indeed, as is always the case in complicated litigation like this, further experts' reports were being filed during the hearing, and in particular, there was a flurry of Luxembourg law expert reports over the Christmas break. My learned friend said that it raised a pure point of law. Well, the discussion with the board, I'm not going to repeat my submissions, but the discussion that took place with the board, or the debate, makes it perfectly clear that there would be a need for further factual and expert evidence. And just as a final observation, no proper reason has been provided as to why Primeo did not particularize and evidence this alternative case. And he accepted it was an alternative case. With that, let me move to causation and loss of a chance. And, my lord, the fundamental point is that Primeo has still provided no explanation for why they did not raise loss of a chance at trial. They knew of the doctrine. We know that because they deployed it in another context. and they raised order to causation in closing. But they pursued their order to causation case purely on the basis of a balance of probability. And we've explained why that was the case. I've referred to it as being they were wanting to have jackpot damages. They obviously made a deliberate decision not to plead loss of a chance, we would say is the appropriate inference. And one can understand why they would make that decision. But having taken that gamble, having made that litigation choice, having decided that that's how they want to frame their claim, they don't get a second bite of a cherry to raise a different case by reference to different facts in front of a further hearing. And it falls fully within the finality of litigation principles, which the SICA failed properly to consider. Now, Primeo now seek to suggest that this was the respondents' fault because of disclosure failures. And as you will have seen from the chronologies that were put in before the SICA, before the Court of Appeal, this is not a new argument. We've been over this several times already. But it's simply not the case. But let's just start by stepping back. Even on Primeo's own case, they received all the custody confirms 1 month before the trial started. They had a large, sophisticated and very, very able litigation team. As your lordships can gather, no effort or expense has been spared in this litigation. It's been very hard fought. They had ample opportunity to analyse the custody confirms and make an order to causation case, either by reference to balance of probability or loss of a chance, if they wanted to. And the reality is that they had no interest in the custody confirms other than for estoppel purposes, while they based their causation case on Mr. O'Neill. And their failure to raise order to causation until closing had nothing to do with late disclosure. They only raised it in closing because they then realized that their causation case required emergency surgery for the reasons I've explained. But actually, even that is not the key issue as to why order to causation was raised late. The key issue is why, when they raised order to causation, they only raised it on the basis of balance of probability, not loss of a chance. They obviously have to accept, it's the point my Lord Sales made, but you did raise order to causation. So whatever was the position in relation to the custody confirms, it didn't stop them pleading order to causation. The relevant question is why, when they raised order to causation, they didn't raise loss of a chance. And that, as I've said, is because the litigation decision they made, they wanted to go for the pot of gold. Well, they've made that decision, and finality in litigation requires that they don't get a second bite of the cherry.
Mr. Gill, something that's slightly hampered me through this hearing is not having a sense of what the price tag is associated with different aspects of the case that was being.
I've got a note that you were wanting to know what the loss of profit.
But also what the what the loss was on the alternative basis, just to give us a ballpark figure.
The most optimistic basis upon which Primeo were bringing their claim was for just under $2 billion.
But made up of what?
$1 billion of that, in broad terms and from memory, was for the loss of future investments.
Loss of profit.
Sorry, loss of profit.
Right.
Loss of profit.
So that's taking the money out and putting it somewhere else where it wouldn't be lost.
Exactly. So that was the issue that Mr. Mr. Thompson's evidence was going to. I mean, that's why the investment management evidence that the court heard was terribly important. We have in the bundle the joint memorandum from the expert witnesses.
1571.
MS 1571, and there you will see the breakdown by reference to each of the 6 redemption dates and the different heads of claim. But in broad terms, on the basis of withdrawing and no future investments, and so trying to claim the profits from the fictitious securities, I think that aspect of the claim on various redemption dates was between $500 million and $800 million. $1 billion in respect of loss of profits on future investments. And then, of course, the real kicker of interest on all of that.
Thank you. That's certainly sufficient for my purposes.
But your Lordship will certainly have that chapter and verse in the Quantum Experts joint memorandum. So, my Lord, coming back, the question of the late delay, even if it's accepted, and I'll show you why it's not, there was no delay in provision of the custody confirms. It didn't stop them raising their order to causation case. And the real issue is, why didn't they raise their loss of the chance case? And on that, there is still a resounding silence. We've still been provided with no explanation as to why they did not raise loss of a chance. In any event, the case that they raised, that there was delay on our part in providing disclosure, which prejudiced Primeo, is simply not correct. And I have to take it sort of fairly quickly, but could I just ask your Lordships to look at the chronology, which we have at bundle 2092. And I can pick it up towards the bottom of that page, and it's the right-hand column that I'd ask the court to look at, which is the respondents' comments on the disclosure. So, on the 13th of March 2015, do your Lordships have it starting about 3 lines from the bottom of the page? On the 13th of March 2015, so as your Lordships know, the trial didn't start until November 2016. Ours discovered to Primeo the emails later relied upon by Primeo at trial to argue that EY had concerns about Freeling and Horowitz and might resign or qualify the accounts. The emails relied on at trial by Primeo to show it is clear that E and Y sought signed custody confirmations from R2 following EY's finding out of about the 2002 sub-custody agreement. So we disclosed to them that EY wrote to R2 and said, we see you've signed the sub-custody agreement, please provide custody confirms. We then, number 4, the emails showing that custody confirms were sent to EY. Now, then paragraph 5, my learned friend says that there's a question mark about the document referred to there. In the time available, we've not been able to clarify exactly what the position is. But then, subparagraph 6, the other 18 unsigned custody confirms discovered by R on the 13th of March 2015, including the custody confirms which Primeo relied upon for the year 2005. Accordingly, upon review of these documents in after March 2015 by Primeo's large team of attorneys and liquidator staff, Primeo would or should have known that EY had requested and been provided with custody confirms from the Bilmis assets. However, Primeo did not amend its claim to include any allegation regarding the custody confirms, notwithstanding it served an amended statement of claim in July 2015, following review of discovery. After receipt of the above documents, Primeo did not ask R2 to conduct further searches to locate further custody confirms, as became necessary for a whole 18 months. Put that in the context that Dr. Farno had discussions with EY in 2005. Put that in the context that the judge found that Dr. Farno knew that the custody confirms were being provided by R2 and were being provided on the basis of single source information. Of course, Primeo, if they wanted to, had ample opportunity to plead at an early stage auditor causation, but they didn't because they were relying upon director causation and Mr. O'Neill's evidence. So, my lord, that's the factual position. But as I say, if one steps back, even that's not really relevant. The real question is, why did you pursue auditor causation on balance of probability, not loss of a chance? And we've still had no explanation. My learned friend said, it's only a very minor point, that no objection was taken to the custody confirms being put to the witnesses. Well, of course not, because they were being put to the witnesses as part of their estoppel case to show that R2 was the custodian post-2005, sorry, post-2002. So that was cross-examination in support of Primeo's alternative case that custodial liability started in August 2002, and we can prove it by putting to you the custody confirms that you have provided and you're stopped. That's the context in which the custody confirms were being put to witnesses in cross-examination, nothing to do with auditor causation. My learned friend asked the court to look at Allied Maples and drew the distinction between causation and quantification. That particular point, I'm not sure, well, it doesn't go anywhere, even for this very, very basic reason, that we'd had the trial on liability and quantum. So whether you're viewing it in terms of going to causation or quantification, it doesn't matter. Primeo had missed the boat. My learned friend said that by the end of the trial, there had to be a further damages hearing. My lords, I've made my submissions on that. We've explained that it wasn't. It was a matter of assistance with inputs into experts' reports. Alternatively, it was just a matter of the judge sitting down with his calculator and doing a bit of addition and subtraction to see what was the balance over the October 2002 to 2007 period. My lords, could I move to the... So that was dealing with causation, loss of a chance. Under that grounds 47, the next aspect that we dealt with was what we described as being the reinvestment decision. So this is the post-withdrawal audit opinion and what the directors would have done. Would they have reinvested back into Bilmis? As your lordships know, there were really sort of 2 points. After fairly lengthy debate with the board, with Lord Sales, my learned friend, I think it's fair to say, finally accepted that a post-withdrawal audit opinion was an implicit part of their loss of profit case. And so that's really the first, the basis of the first round of challenge. It was, the SICA had said it wasn't open to the judge to find there would have been a post-withdrawal audit opinion. I made the point that the judge had a more nuanced understanding because it was an implicit part of Primeo's case that a post-withdrawal audit opinion would be provided, and we've finally been provided the confirmation that that was indeed Primeo's case. So that's the first part of the reinvestment decision dispute. On the second part of that dispute, namely, would the directors have reinvested in Blimis, or would they have reinvested in US index equity funds, as suggested by Mr. Thompson, there can be no question that the trial judge was in an infinitely better position to make an assessment of that. And one can see that that was at the center of the judge's decision, because he explains in paragraph 267 that this is what would avoid early redemptions. And for those who were at the trial, we know what bell the judge is ringing at that point. He's referring back to Mr. Thompson's evidence and the fact that any investment in a fund other than Blimis would have had higher volatility and lower returns. There would be an exodus of investors. And that's why, I'm sorry, it was Mr. Lowe's evidence, not Mr. Thompson, Mr. Lowe's evidence. Why there would be an exodus of investors, and that's why the directors would have reinvested back into Blimis. My learned friend did not in any way challenge what I said about their case, which was that it did not suggest that a failure to issue a pre-withdrawal audit opinion would excite suspicion of fraud. And I showed you that that was not how the case was being put. On the contrary, it was accepted that nobody should have had suspicions of fraud, because otherwise that would have triggered reporting obligations, which would have stopped withdrawal and investment of future profits. So that key second aspect of what we say underlay the judge's nuanced understanding of what was happening here, of how the case has been put, again, that's not been challenged. And then finally on this, no explanation, we would suggest, has been provided by my learned friend of how SICA could have concluded that the judge's decision on this point could be deemed irrational. SICA wasn't making this decision de novo. They weren't the trial judges. They had to explain why the judge's decision was irrational. And I'm afraid to say, we say that the SICA's judgment doesn't come within a country mile of that when one understands the complexity of this litigation and how Primeo was putting a very, very strategic case because it was going for jackpot damages. My lords, in terms of contributory negligence, so this was issue 8. Well, your lordships know what it in terms of the reduction for contributory negligence. I don't have a right of reply on the law in relation to Vesta and Butcher and limitation, so I'm not touching on that. So I'm just talking about the appropriate reduction for contributory negligence. My learned friend said that SICA was right to take account of the fact that R1 was a professional service provider. And that, with respect, rightly led Lord Sales to ask whether it was being said that the judge had not taken that account, had not taken account of the status of R1 and, by implication, defendant fault. And in our submission, it is untenable to suggest that the judge had not directed his mind to defendant fault. So, obviously, the judge at paragraph 319 is only referring to plaintiff fault, because all of the earlier part of the judgment is dealing with defendant fault.
And I wonder whether it might be said that even if you go through the whole of the judgment up to 318, one doesn't find the judge telling himself that the obligation of a professional in these circumstances is a particularly weighty matter. And indeed, you, in your submissions previously, had said, well, that's the way that you deal with those cases, the part of the case that Mr. Smith had abandoned as a complete answer. But you say, well, yes, professional obligations are an important and weighty matter. And at the moment, I'm speaking purely for myself,
yes.
I don't see the judge drawing that into his account of the balance to be struck for the purposes of contributory fault.
But my lord, the context was that at trial, my learned friend had made the same submission that contributory negligence against a professional defendant should always be zero. And so it's the case of Bader, the four cases that my learned friend sort of abandoned and did not pursue. Right. I mean, basically he was saying that there is a rule of law that you can't raise contrib against a professional service provider because the very duty of the professional service provider is to protect you against that risk.
Yes, and he lost that argument, but you have confirmed that ordinarily, the undertaking of a professional obligation to check something will be a weighty matter for the purposes of balancing fault.
And that is something that was well understood by the judge and flows out of all of the argument that we had in relation to these cases.
Where do you say that he's balanced that factor in his judgment?
Well, we say that is all just completely implicit in all of the analysis that had been conducted and the arguments that we had in relation to whether contrib was available against a professional service provider.
The way the Court of Appeal deal with this, they cite a number of times a dictum from Jackson and Murray, contrasting a finding by a judge that one party was substantially more responsible than another, and on the other hand, a view on the part of the appellate court that there's no reason for distinguishing between the comparative responsibility of the parties and saying if you're in that area, it's legitimate to interfere. One might infer from the fact they keep citing this dictum that they took the view that the judge had gone wrong in taking the view that Primeo was substantially more responsible than R1 was for the loss.
Yes. And as I hope I made clear in my submission, one of the critical factors which in our submission justifies the decision is that Primeo decided to put all their eggs in one basket. So they, despite everything they knew, despite the judge finding that they would have been willing to amend the terms of the custody agreement and everything else like that, despite everything they knew, they put 100% of their assets with Billness. And as I said, I don't want to repeat my submissions, but if you were asking yourself in terms of causative potency and blameworthiness, which of course is the test that is being provided, that in our submission fully justifies the judge's decision for finding that Primeo was very substantially the author of its own misfortune. And whether, in a sense, one agrees with that or not, the question is that irrational? In terms of an assessment of what is just and equitable, could it be said that it's an irrational decision for a judge to come to that conclusion? We would say no.
Yes, I mean, when you refer to all that they knew, I mean, the Court of Appeal at paragraph 507 do identify the fact that R1 and R2, R1 and HSBC had serious doubts internally as to what they could do, which they didn't tell Primeo about.
And I explained to your Lordship that was just factually wrong, because the judge's finding was that he had not withheld any information. And we've given those references in the case. So just in terms, and that was one of the specific matters that they were relying upon in support of their allegations of recklessness against Mr. Fielding, and the judge specifically rejected that. So just in terms of facts on that, we say that the Court of Appeal was wrong. But just coming back to the balancing exercise that the judge was doing, the judge has, if I can ask your Lordships to just go back to page 313, paragraph 313 in the judgment, we have that at page 175. So the judge there sets out the terms of the Act, and he obviously, having done so, can understand that he is assessing defendant fault against plaintiff fault.
Yes. But my point is, where does he bring into account a point that you yourself have accepted is an important and weighty factor, the fact that the defendant has assumed a professional obligation to take care into the very matter that has eventuated as a risk?
I don't think I can point to a sentence in that the judge took that into account specifically in the context of contributory negligence. He obviously refers to the fact that they are professional service providers. He was assessing that in the context of the duties that they owed, particularly against R1. He was accepting that it was a question of professional judgment. So he was steeped in the fact that these people were paid and they were professional service providers. Now, I'm perfectly happy to accept that the learned judge often expresses himself in quite terse terms. And one sees in Jackson and Murray that the court doesn't criticise judges for expressing conclusions on contributory negligence in brief terms, particularly in the circumstances of this case, where the judge has found that the liability case has failed. So he is dealing with a possibility on appeal. And that, in our submission, further entitles the judge to express himself relatively briefly. We would suggest that it is unfair to a first instance judge in these circumstances, having produced such a detailed opinion, as such a detailed judgment, to suggest that the judge should be required to say, and I remind myself that they were a professional service advisor and they were being paid. In our submission,
and that is a weighty factor, and that is a weighty factor for the purposes of the balance.
And that is a factor and a weighty factor that I need to take into account. I would have thought that is completely implicit in a reading of the totality of the judgment.
Thank you.
Would you say that also implicit is in the judge's reasoning is that R1 was grossly negligent?
Yes.
Because, I mean, there's blameworthiness as well as causative potency.
Yes, absolutely. I mean, that is undoubtedly the conclusion that the judge reached post-2005, and that is the basis upon which he is undertaking the comparative evaluation. So, my lords, we do say that it is, how my learned friend was putting it was effectively to try and suggest that the judge had failed to take account of defendant fault, because you just look at what he says at paragraph 319. That's untenable. At 319, the judge is quite clearly just dealing with plaintiff fault. He doesn't expressly articulate the nature of the defendant fault, because we say that's self-evident from all the rest of the judgment. If that's the basis upon which my learned friend is suggesting that the Court of Appeal was entitled to interfere, we do say that that was fundamentally wrong. Some credit has to be given to the judge. He knew the comparative exercise he was performing. He'd referred to that at paragraph 318, and in our submission, just because he didn't expressly refer to it, it would be an unfair conclusion to think that the judge had not taken into account the nature of the duties that the respondents owed and the nature of their breaches. My lords, my time is up, and so unless there's anything further that I can assist you with, those are our submissions. Oh, I'm sorry.
Scott schedule's close to being.
And my lords, I'm told the Scotch schedules are close to being agreed between the parties. I had a look at the formats last night, and I think you'll find that they are quite useful. What is taking a little bit of time is that they are also inserting into the Scotch schedule the transcript references, so that you can see where different issues have been dealt with orally, and I suspect that that will be of assistance.
Yes, we'll look forward to receiving that, I hope sometime next week.
Yes.
Well, thank you, Mr. Gillis. We're grateful to all involved for the quality of the submissions, both written and oral, that we've received on both sides of the case. It's been a very well-argued case, so we're appreciative of that. We'll now take time to consider what advice we shall tender to Her Majesty.